I request most of the law students that you have to select that in which area you want to work. Because this is the only profession where a single thing, whatever you have done, will not go into the waste. It will not go into the vain. Why? Because even if you are walking on the street, there is a hawker is sitting on the street, you know that he has certain rights. If somebody is hospitalized, you know that how doctors should have been dealt with this matter, whether it falls in the consumer affairs or not. You can also see the tree is being felled for the construction of the road. You know that whether the authorities has taken proper care and permission for the construction of road or not. They have taken this permission to fell the tree or not. So the smallest thing, what you observe on the street, that is in the purview of the law, that falls in the umbrella of law. So each and every lawyer, because I don't know that when this is current gathering, someday some of you maybe we may interact as a high court judge. Someone may be professor, someone may be top lawyer, somebody may be contesting some election in some bar association and then very popular and famous lawyer. One thing you must remember, that this profession is very lucrative, but only for those who are working hard. There is no substitute of hard work. That's why there is a popular saying only that law is a jealous mistress. Jealous mistress means that if you are focusing on something else, at the time when you are studying law, it may not give you the complete goal what you want to achieve, and it may fail you, it may divert you, it may take you to somewhere where you may regret that why I opted for this legal profession, why I joined LLB.
What exactly is litigation? Litigation is the act of practice, the process of solving a dispute inside the court. So that is litigation. Now you all are all students and you all are in your first year, second year, third year, fourth year, fifth year. So normally what entices you all to practice? It is mostly, whether you like it or you don't like it, you all already decide whether you all want to go into litigation or you all want to go into firm practice or you all want to be appointed as legal advisors in banks or companies, big companies where the salaries are very lucrative. So ultimately it is what drives you to litigation is solely your passion. So when you want to litigate, when you want to fight, litigation is going to court representing a client. Either he is the plaintiff or the defendant, and you fight for him. You show the court the law, the present the facts, and then you ask for justice. You present the case to the court. So that is basically litigation. So
highly debated topic so far as death penalty is concerned. There is a school of thought of academicians and intellectuals, activists who don't really approve of this mode of punishment. But then the fact remains that we still have it. Although there are a number of countries who have done away with death penalty, but in our country we still have, and there are various offences under the Indian Penal Code where death sentence can be awarded, and apart from IPC, there are also other acts such as NDPS Act, so where death penalty can be awarded for different offences. Now, I've had occasion to do some of the cases, to appear in some of the cases where the accused concerned was awarded death sentence, but I'll talk about them later on. They're not a part of this presentation.
Of the time, states act in accordance to international law as well. Some people say international law is not sufficient, or because it has failed to maintain international peace. They do not keep in mind that law cannot dictate the politics and behavior of states. Also, international law cannot prevent its violation, like criminal law cannot prevent crimes. International law is a means to handle a situation, like operators within the legal system.
Reproductive rights are not really defined separately in the Constitution.
it comes into the ambit of Article 21, which is the right to life, because it is an integral part of a woman's life. It also has some shades from Article 14, because Article 14 prescribes equal protection of laws to all equals. That's the affirmative action. Equality is what our Constitution prescribes. Our Constitution does not say equality of all, irrespective of whether they are equally placed for us. That is why affirmative action for them. And then there is the directive principles of state policy in the Constitution, which specifically mandates the legislature, the government, successive governments, work on equal opportunities for women in workplaces, equal pay for equal work, also maternity leave being enrolled into social
Judgment law in this country. There is no statute. So for it is a statute, there is no issue of case of development of law. It is a statute-made law and it is to be interpreted. But administrative law being a judgment law, develops or interprets on the basis of the judgments which are rendered by the courts. There are two aspects of this particular law, that is administrative law. That is, one, it becomes a precedent to the courts. That is, a particular judgment is rendered by the High Court under administrative law. It becomes a precedent to the court in subsequent judgments. It also becomes the rule of law for the administrators, the executive, who have to follow these rules, because there is no statute in administrative law in this country. Therefore, for every aspect of administrative law, it is a judgment law which occupies the field. Therefore, it is a guidance to the practicing lawyers and the in judiciary as a precedent, and also a kind of a rule for the executive. Now,
Chaudhary's case and Mamta's case. This was, and then in fact, the names are not said. It is in the case of X or in the case of Y and things like that. So, but what is very important is, see, the Medical Termination of Pregnancy Act came into effect on 2nd August 1971. So it came 51 years ago. Why did it come? It came actually to enable women, married women, to undergo a safe abortion procedure, because women that time they did not have a safe atmosphere to go and have an abortion. They had only access to PACs and illegal centers, which led to a lot of maternal mortality rate. So that is why this thing came up. Now in 2021 there was an amendment to the Act of the Medical Termination of Pregnancy Act, wherein they replaced the word husband with that of a partner. Despite that, the legislature
publish sensitive and private material on any electronic media. This particular type of cybercrime is on the peak in Delhi as of now. I don't know about other states, but in Delhi, this particular cybercrime, online extortion is on peak. Apart from that, credit card fraud and debit card frauds, I'm pretty sure you must have heard about all these. These are very old type of frauds now. And the other one is phishing and impersonation and identity theft. All these things comes under cybercrime, and not the cybercrime is not limited to only these heads. The crime, such type of crime is like vast. So even cyber stalking is involved in all these things. Even online trolling involved in cybercrime. So all these things are cybercrime. So in India, cybercrimes are covered majorly by 2 acts. So as a law students or as a budding lawyers, we should know that. Now I would like to inform and notify all of you guys that cybercrime is one of the very upcoming field in which a particular student can make a career in, because cyber now is
370 is a constitutional provision that gave Jammu and Kashmir its special status. The provision was, as I told you, incorporated in Part 21 of the Constitution. It was a temporary, transitional and special provision.
it has been abrogated. If it was a permanent provision, then obviously it will not be abrogated. So as evident from the part, it was supposed to be temporary provision and its applicability was projected to last till the formulation and adoption of state constitution. It restricted the parliament legislative power with respect to the state of Jammu and Kashmir. Pandit Nehru, on the floor of Lok Sabha on 27th November 1963, said that Article 370 has been eroded and the process of gradual erosion is going on. A year later, so Article 370 is
in a phrase, functional equivalence. When the IT Act was passed, it amended the Indian Penal Code, it amended the Evidence Act, it amended the Bankers Book Evidence Act and other laws, enabling all of them to be applied to the internet. The IT Act is a connector also. And in law, there is a distinction between the law of the medium and the law of the machine. And we've seen how national governments have enforced the law. Adobe Systems inviting a Russian hacker called Dmitry Skylorov to the United States so that they could arrest him. A ploy used time and time again. But our IT Act is also very clear that the Indian law enforcement, the Indian Information Technology Act will apply to any offense involving a computer system or network in India.
Social and emotional reasons, and also the role of local bodies such as Khap Panchayat, particularly in India, and also then the relevant statutory provisions, which I will just run through the slides, and since you already has, you can see the slides. And then there are some cases which we've compiled for us to sort of broadly examine the issue. So, can we go to the next slide? So, as we've already been told while discussing while having the introduction, that it's generally the women who are the main victims. And why? Because they are considered to be repository of family owner, and they are considered as inferior to the men, and the men are supposed to be protecting the honor of the family, which is where the victims are usually women. But it is not that it is only confined to women, it also happens to men. Even men are sometimes victim of honor killing, particularly in interfaith marriages.
In corporate legal practice, you are not asked about law. You are asked to draft a contract or review a contract or negotiate a contract. Most of the times, adequate time is not spent on contract drafting skills at the college level. Even if drafting is there as a subject, the study is divided into so many kinds of drafting, pleadings, complaints, notices, so on and so forth. So the time left for contract drafting is very less. Workshops and interactions like this try to bridge this gap between academic knowledge that you attain at the law college.
Important, I feel. Very important in the judgment to find that para 479 of Justice Nariman's judgment.
That privacy is not a vague concept. And I quote now, the argument that the right to privacy is so
are broadly classified into interests pertaining to the physical realm and interests pertaining to the mind.